Hello everyone, and thank you for joining this Ius Laboris webinar. My name is Annie and I will be facilitating the session for you today. So today's presentation will be given by a set of panelists, all from different member firms of Ius Laboris. We have lawyers from Italy, the US, France, and Spain joining the panel today. Okay, that's all from me. I'm now turning over to Marco to start the session.
Thank you very much, Annie, and welcome everyone. Even though these welcomes still sound weird 1 year on, because you're telling them to an empty room and in front of a screen, that is now reality for many of us, and that is our starting point. When we were first discussing the topics for this webinar, the title came up, and it's Navigating the Pandemic, which is what we've been doing collectively over the last year, both in our professional and personal life. That sounds irrelevant because, again, it's what's happening, but it's not, because what we've seen happening is also a blurring of borders and divides between professional and personal life. We've worked and we're working from our homes. We're transmitting from our kitchens to boardrooms across the globe, or we're dealing with everyday chores in a way we wouldn't have expected before. The look we're hoping to give you today is about what went on and what will go on in this environment. So start from legislation from all countries and try to have a general look at things that are common. So how to deal with vaccination, they're coming in different forms. What did governments do employment law-wise to navigate this pandemic? Let me introduce you briefly. It is a pleasure to the other panelists. They come from France, Kayla, and the US, Rachel, and Spain, Gisela, and they will navigate with me through their computers on this webinar. The first topic is a general one, is an introduction one, and it's simply titled 1 year on. So what went down and what happened. From an Italian perspective, it's a very high level summary. What happened is the Italian government, employment law-wise, decided to try and keep things as they were, banning reorganization and economic dismissal for the duration of the pandemic. The ban is still in place, and regulating life in the workplace. Life in the workplace that has seen the inclusion of many players that beforehand were simply taking a back seat with the performance of the working activity in the companies. Company doctors, which were seldom mentioned in webinars or legal reforms in employment fields, are now at the center of the assessment that an employer has to take. There are new documents that must be adopted, and above all, a COVID-19 protocol, which regulates each workplace needs and obligation, and basically dictates the rhythm of the working life. On the same track, we have the smart working, which is our way of calling remote work, because the legislator decided to use that term. And we had legislation on smart working and remote working dating back 2 years when the pandemic started, 2017, which has taken on development forced by the situation. So more and more companies are managing their workspace through protocols and their workforce through smart working policies. It is still simplified because it came into effect with the pandemic, but we are waiting and looking at evolution in this field. Unions are part of the deal, as are health and safety representative and company doctors. There is, and still we're in Italian soil, an attention to furloughs and a corresponding ban on dismissals to hold our collective breath, hoping the pandemic will pass. Of course, if this will prove a sage way forward, or if it will lose precious months in reorganizing the workforce, that's a question for the ages, not for our webinar today, or maybe for the Q&A section if we have time at the end. But let's now have a look abroad, and let's see the situation 1 year on in our other countries of webinar residence, starting with France and with Kayla. And I was wondering, considering that France has been known to both be active on the work from home front and the vaccination front, what is going on around the country nowadays? Thank you.
So for some time now, employers, where possible, have been required or very strongly encouraged by the government to have their employees work from home. So for some employees, it means that they've been working from home for nearly a year. For others, it's been less time. But some of the considerations you really should be having now are, how do you ensure, in a way, how do you protect yourself as an employer? You have all of these employees who are working from home. What are the steps that you should be taking? And one of them is to make sure that they know how they can disconnect, or how they can exercise the right to disconnect. Because employees who telework have a right to work-life balance, which means that you should communicate with them, if you haven't already, how they can disconnect and what the consequences of disconnecting will be, such as they are not obligated to check their emails, they're not obligated to respond to telephone calls, they're not obligated to respond to texts during hours outside of their normal work hours. And this again is to protect their work-life balance. Managers should also be checking in regularly with their employees, with their subordinates, to make sure everything's okay. What's their workload like? Is it too heavy? Is it not enough? Are they feeling isolated? Do you need to adjust their working hours, maybe, to also take into account, their own personal obligations? Maybe they have very young children who need to stay at home with them. It really is a question of managing and making sure everyone is doing well in terms of health and safety, in terms of working conditions. And it's a good practice, even a great practice, to have your managers take notes on their conversations with how things are going with each employee, so that later, should an issue arise, should an employee say that they're burnt out or they're suffering because of this work from home situation, you'll have some documentation to support your position that as an employer, you took measures to protect their health. In terms of vaccination, today is the first day that employers are permitted, or not employers, but that individuals between the age of 50 and 64 with comorbidities are eligible for the AstraZeneca vaccine. And this vaccine can actually now be given by the individual's personal doctor, or it can be given by the occupational health doctor. And in that case, employers have a general obligation to inform their employees that they can actually receive this vaccine through the occupational health doctor.
Thanks, Kayla. Oh, sorry. Did I cut you off?
I was just going to let you know I finished.
That's perfect. So we are on the same page. Thank you very much. Thanks, Kayla, and thanks for confirming that, say, both personal life, personal doctor, company doctor, work-life balance, time at home, time of work are being readjusted in reality as we go along. And let's travel across the ocean to the US, where, hi Rachel, first of all, and welcome from Texas, where I have one question at the beginning, which is, I noticed you had a presidential election recently. That's something we have heard, don't know if it's confirmed. And did this have an impact? It is. And did this have an impact on the way the legislators and policymakers are looking at the pandemic in the workplace?
Yes, most definitely. The Biden administration is being very active regarding coronavirus and a coronavirus response. Their focus right now has primarily been on rolling out the vaccination program here in the United States to all of the individual states who are then passing it on to the citizens. And we'll talk about vaccinations a little later. But we're expecting from the Biden administration a very active administration when it comes to employment issues surrounding coronavirus. OSHA is taking, our Occupational Safety and Health Administration is taking a very active role now, looking at employers, whether they are putting forth coronavirus protections for their employees. In addition, we expect the Family First Coronavirus Response Act, which provided paid leave to employees dealing with coronavirus issues, that ended by its terms on December 31st, 2020. It was sort of expanded in January to allow employers to still provide the leave and receive the tax credits they were receiving until March 31st, 2021. We think with this next round of legislation, coronavirus relief, that our legislature is working on, now that we have finished impeachments, to do more leave with this administration. In addition, we are really expecting states to become more active in setting forth liability waivers or liability protections to employers who are being sued related to employees dying as a result of coronavirus. Certain states, such as Georgia, have already passed that type of legislation, and we can expect to see more of that with this new administration.
Thanks, Rachel. That's really, really interesting, and it's also very interesting to see the difference between the US and Europe about the general attitude towards this legislation. What you were saying, the state laws do have a great importance, and then the change in administration did impact the general direction of the managing of this. And let's come back to the old continent and let's go to Spain. Gisela, Spain and Italy have many things in common, a fixation with football or soccer being one of them, but also a ban on redundancy dismissals or reorganization dismissal during the pandemic. Is there a ban currently in Spain? And if an employer decides to move on with dismissals all the same, what are the risks and the limits?
Yeah, Marco, thank you very much. And indeed, as you have mentioned, this is a real trending topic here on unemployment law in Spain, basically because Spanish courts and Spanish tribunals have issued contradictory resolutions on the legal qualification of dismissals carried out, while the legal prohibition to dismiss for causes related to COVID is in force, which is in force actually based on current legislation until the 31st of May this year. Basically, if we can identify in two different groups these contradictory resolutions. In one group, we could find the resolutions from the High Court of Justice of Madrid and the High Court of Justice of Catalonia, which consider that these dismissals shall be declared as unfair. On the other hand, or on the other group, we have the High Court of Justice, the resolution of the High Court of Justice of the Basque Country, which says that these dismissals carried out while the legal prohibition to dismiss is in force and for causes related by COVID are null and void. This is very sensitive, it's a sensitive matter because the legal effects on these two different types of dismissal declarations are totally different. In the case of an unfair dismissal declaration, the employee will only be entitled to the payment of the statutory unfair dismissal severance. And that's it. The employment relationship is terminated by only paying the corresponding dismissal severance. On the other hand, if we face a new dismissal declaration, the employee will be automatically entitled to his or her reinstatement in the company. And on top of that, the company will have to pay all the salaries accrued from the termination date until the notification of the court's decision. Okay, so basically, what do we think? From our legal interpretation, from our legal perspective, we consider that this type of dismissals shall be declared unfair, not null and void. However, we will have to wait for a final decision to be issued by the Supreme Court of Justice in order to have certainty on the legal consequence or effects of those dismissals carried out, while this legal ban to dismiss for causes related to COVID is enforced.
Thank you very much, Gisela. And again, very interesting. I think that summing up this segment, what we can say is that the law is following what happens in the world. And that's the only way it can be it on vaccination, be it on general policies towards coronavirus, or be it on dismissal law. So we are witnessing laws changing as we go along, and that cannot be any different. I will now talking about new things, and over to Rachel, who will talk to us about vaccination and the wider implication it's having in employment law.
Thank you, Marco. Vaccinations are on everybody's mind now. We now have several companies worldwide issuing the vaccinations. Here in the US, it's primarily Pfizer and Moderna, though Johnson & Johnson is expected to be approved later in the next few weeks. And Johnson & Johnson will be a game changer here in the US, because it's the only shot available that's going to be available that only requires one dose, while as Pfizer and Moderna both require 2. In the US, what everybody's asking is, can we mandate vaccines in the workplace? And technically the answer is yes in the United States, but the legal issues are quite complex. We have the Americans with Disabilities Act, which protects people who have a disability, and the ADA requires limits employers' ability to conduct medical examinations on employees. And a vaccination itself is not a medical examination under the ADA, but the pre-screening questions that you receive before you get a vaccination, such as, are you taking these drugs? Or do you have a certain disability, will qualify as a medical exam. So if an employer mandates a vaccine, the pre-screening questions must be job related and consistent with business necessity. An employer can't take an adverse action against an employee who refuses it unless they can demonstrate the employee poses a direct threat. Now, you would think coronavirus has proven to be a deadly virus for some. Can't we just show that it's a direct threat because they may get coronavirus and give it to other people? Well, the fact of the matter is right now, it's been a year in, and we have spent the last year at work for the most part in the United States with masks, social distancing, hand washing, those types of things. It's kind of difficult for an employer to argue that an unvaccinated employee poses a direct threat when we've been doing these types of things for the last year. And then if an employer administers the vaccine, but it's voluntary, meaning the actual employer is doing the shot or hiring somebody to do the shot, an employer can't retaliate or intimidate or harass an employee for their refusal to take the vaccine. You can mandate, a US employer can mandate the employee go through a third party of their choosing. That's perfectly acceptable, but you also have to deal with various accommodation issues, such as employees who are refusing to take the vaccine due to a closely held religious belief, or an employee who's refusing to take the vaccine because they have a disability. As far as religious accommodations are concerned, I expect this to be probably the bigger issue when it comes to vaccinations in the United States, because most doctors are not putting out notes for their for their patients saying you can't take the vaccine because of this, that, or the other. The science just doesn't back that up as far as doctors are concerned. But we're seeing religious accommodations a lot more, and a religious belief in as far as Title VII is concerned is really just a closely, sincerely held religious belief. It doesn't have to be an organized religion. It doesn't have to be a part of a bigger church or traditional thinking religion. It can be something that an employee just truly believes to be their religious calling. And an employer has to accommodate that. Disabilities, you have to go through the interactive process. And again, to make sure there's no direct threat, again, we have the same issue related to, we've been doing this for a while now. How can you show it's an undue hardship or a direct threat for an employee not to go about work using the masks and social distancing now, when it was perfectly okay before. If an employer can require proof of vaccinations, and there was a lot of concern in the beginning about what that was going to look like for employers. The CDC actually kind of took that concern away from employers here in the United States. And what the CDC is now doing is issuing vaccination cards to every single American who has been vaccinated. And you get that card. I've received both doses of Pfizer. You receive that card when you get your first shot. It gives the name of the manufacturer, the bin number of what vial you got, and then the date you received your vaccination. And that's really the only information that's contained on the card. An employer can require proof of it. They can look at it for an employee and say, okay, yes, you've been vaccinated, but you have to keep the results of that information confidential. And finally, the biggest talk right now is, can employers offer incentives for their employees to get the vaccines? And it's an interesting issue, and it's an undecided issue in the United States. The Trump administration had put forth some guidelines under the ADA unrelated to COVID, related to wellness plans. And there's some debate whether vaccination incentive programs would fall under these types of wellness programs contemplated by these regulations. The problem is that those regulations were all rolled back when President Biden came into office. And so groups are now asking, employer groups are now asking the Department of Labor for some guidance on what kind of incentives can employers provide. Some are just saying, look, we're going to give you, every employee gets vaccinated, gets a $50 bonus. Others are doing it a much higher rate of like $500. And that's very questionable right now. So any employer that's thinking about doing incentives should really talk to an attorney. So let's talk about what other countries are doing. I could go on and on about vaccinations, but let's talk about what other what other countries are doing with regard to vaccinations. Kayla, can employers require employees to be vaccinated in France?
No, we can't. Employers cannot require employees to be vaccinated. At least at this point, that's the position the government has taken. And employers should also be aware that they should not collect information on whether employees are vaccinated.
Great, apologize for my dog. It's the life of work from home, right? Can employers offer incentives to promote employee vaccination?
It's a really good question. And in theory, they may. However, because vaccination isn't mandatory, employers need to be really careful because giving an incentive could also raise unequal or discrimination claims by employees who decide not to be vaccinated. So employers should definitely speak with their works council, called the Social and Economic Committee in France, and their occupational health service before they offer any incentives. And again, you need to be really careful about avoiding any direct or indirect financial incentives or disincentives. And you also, I know that incentives, the most effective incentives are probably cash incentives, but at this point, our advice would be to be wary of those types of incentives. You can definitely encourage, you can have your works council encourage vaccination, explain what the benefits are, how it'll help the company, how it'll help the individual, their colleagues, et cetera. But right now, I think employers in France need to be careful about incentives.
Great. Anything else employers in France need to know?
I think those are the most important parts about vaccination, apart from what I said earlier, which is that now you should be informing your employees that they can receive their vaccination through the occupational health doctor.
Great, thank you, Kayla. So Marco, in Italy, how can an employer balance the duty to protect work environment and the freedom of each individual to refuse a vaccination?
Well, thanks, Rachel. What you mentioned is the two pillars, legal pillars we're moving between. So the employer has a responsibility and a duty to keep its employees safe and in health. This goes through the COVID regulation, of course, and all the protocols and rules I was mentioning earlier are applied in this respect. And the role of the company doctor is very prominent. On the other hand, at the moment, vaccines in Italy are public, so there is no way to run a private vaccination system or for an employer to buy vaccines and mandate them or propose them to their employees. They are optional, so there is no legal obligation to be vaccinated, and they are being managed through categories of citizens. So both from an age perspective and from a role/work perspective. So the over 80s are being vaccinated, medical staff is being vaccinated, teachers are being vaccinated, and so on and so forth. Lawyers between 40 and 50 will be vaccinated likely in 5 years' time or something like that, if we keep this pace. But that's a personal problem. So there is no mandatory vaccines, and they're public. The employer cannot impose them, and the only way an employer can look at imposing a vaccine, even if it's a very small road, is through the protocols that is required to adopt for the working place. So if a company doctor with specific relation to that working place and that activity deems the vaccine as a necessary condition to access the workplace or to perform the work, that's the only legal space we have right now. One thing to be mentioned here is the Data Protection Authority took a very clear position on employment and vaccines, saying that the employer cannot ask confirmation about vaccination to its employees, that the employer cannot ask the company doctor to name employees who have refused to take a vaccination. And on top of this, saying that if the vaccination is required as a specific need to access the workplace, the answer of the Data Protection Authority is let's wait for the legislator to rule on that, but the current legal scenario is very uncertain. So we are still waiting for development on that count.
Great, thank you, Marco. Gisela, Vaccines in Spain, I understand, are now only available to limited groups. When the rollout becomes more complete, how do you expect the Spanish government to respond when it comes to employers?
Thank you, Rachel. Yes, as you mentioned, right now vaccines are limited to specific groups, okay, identified and listed by the government. But once vaccination becomes available to everybody here in Spain, we think that it would be possible for employers to encourage their employees okay, not oblige them, but to encourage them to be vaccinated by, for example, implementing several measures. We could talk about paying or assuming the vaccination costs. In this specific case, what the employers will have to do is to inform the employees about the pros and cons of being vaccinated. But on the other hand, what employers could also do in future is just to pay some incentives to those employees who decide to be vaccinated by requesting, for example, the corresponding vaccination proof. Okay. In any case, what it is very important right now from a Spanish perspective is basically two things. From one side, you must be aware that the employee is free to decide, is free to accept, I'm going to be vaccinated or not. Okay, so this is something that will only depend on the employee and will require his or her consent. And on the other hand, what you must be aware is that the employer cannot sanction the employee or cannot take any kind of decision that may affect the employee due to the fact that he refused to be vaccinated.
Thank you, Gisela. I know we could probably talk about this topic for an entire hour, but I think we have to move on to, let's talk about we've been working from home for about a year now, and a lot of companies are making that decision to go longer term. So let's talk about that. Gisela.
Yeah, thank you very much. Annie, please, if you can go to the next slide, that would be fantastic. Okay, so thank you very much, Rachel. Thank you very much, Annie. Well, here in Spain, we have good news, bad news. We have new legislation. And in fact, since October last year, okay, we have a new Remote Working Act, which was approved by the government due to the fact that a lot of people start working at home. And they said, okay, we are going to implement this new Remote Working Act. Basically, what you have to take into account are two things. This act imposes several obligations to employers, okay, but it will only apply to those cases where at least 30% of the whole working time is provided on the remote working basis within a reference period of 90 days. Okay, so it does not apply, for example, to those cases where an employee will only work from home 1 day per week. Okay, likewise, you have to know that this act will not apply to those cases where the company decides to require their employees to stay at home, okay, and to work at home and to not go to the office in order to avoid any kind of infection case due to COVID. So basically, imagine, for example, that we have a company, and in this company, the corresponding prevention service decide that due to the total headcount, the limited space in the work center, it is necessary that 60% of the employees stay at home, working at home. Okay, and therefore, this 60% of people will stay at home working. In such a specific case, all the regulations included in this new Remote Working Act will not apply because the company's decision leading to the employees working from home is as a result of a measure in order to avoid COVID-19 infection cases. Okay, but in any case, in a regular longer-term home working scenario, so not related to COVID issues, in a regular one, what you have to know is that this is something voluntary. The employer cannot impose on the employee on a unilateral basis the obligation to provide services on the remote working basis. So it is absolutely necessary to get the employee's consent. Likewise, if an employee has been engaged to provide services from the company's office, and then during the employment relationship, the parties agree, no? For example, the parties agree that, okay, now 3 days per week, you are going to stay at home, you're going to work from home, and that's it. And then the 2 remaining days, work from the office, that would be possible. But in such a specific case, the law allows any of both parties, the employer or either the employee, to return to the office work by only complying with a specific prior notice informing the other party that they will revert to the previous office work scheme, okay? And this prior notice could be agreed either in the employment agreement, a specific agreement that will have to be concluded by the parties, or could be regulated by the applicable collective bargaining agreement. In any case, what you have to know right now in relation to the main obligations employers will have to consider are basically the obligation to sign a written remote working agreement, regulating several matters, several topics expressly listed by law. The ones you could check in the PowerPoint presentation, but they basically refer to term, for how long the employee will work on the remote working basis, all the tools the employers must provide to employees working from home, as well as all the expenses that the employee will incur for the provision of services on the remote working basis, and how these expenses will be paid by the employer. Okay, because the employee cannot assume such costs. So such costs must be assumed by the employer. So the employer could reimburse those expenses, or maybe the parties could agree on a specific amount of money that will be paid on a monthly basis, for example. Then it is important for this remote working agreement to establish the timetable that the employee or the remote worker employee will have to comply with when providing services from home, and specifically the availability hours, because maybe he has to be, for example, he has to work from 9 till 5 p.m., but he should only be connected through IT platforms, for example, for specific times from 10 till 12, and that's it. So that's something that you could also regulate in the remote working agreement. Then you will have to specify if there will be any mix between home office and home work and office work. Also, the prior notice applicable to go back to the office work schemes. Then, very important, the business control measures on the labor activity, basically the controlling and monitoring faculties of the employers, in this case, data protection, information security measures. This is something that should be also covered by the remote working agreement. Please note that it is important and it's mandatory to conclude this kind of remote working agreements. If you do not do that, you could be punished with an economic fine that may range between 600 and 6,250 euros by the work inspectorate and per employee. So very important to take into account. What happens, for example, if you say, yeah, but now I am obliged to sign this kind of agreements with my remote worker employees? Different scenarios, depending on when the employee started providing the services on the remote working basis. Please remember that all remote worker schemes implemented as a result of the COVID are fully excluded from the application of this law. And therefore, we could talk, for example, about right now, we decide to engage an employee that will provide services on the remote working and the remote work basis. If that's the case, on a permanent basis, we will have to sign an agreement regulating all the topics that we have discussed. But what happens, for example, if the employees started providing services on the remote working basis before this new act came into effect? Well, in such case, we will have to take into account the regulations that apply to such remote working schemes. If such remote working schemes were concluded before 13th of October 2020 by taking into account a specific remote work regulation on collective bargaining agreements, either of industry or of company level, in that case, employers will have 1 year to adapt all the provisions of such previous remote worker agreement to the new regulations established by the new act. However, if those previous remote working agreements were concluded just based on the agreement of both parties without any kind of regulation by a collective bargaining agreement, in that case, they will have to adapt all the provisions to the new act, and they are right now enforceable. So that's something that you will have to do right now in order to avoid any potential sanction from the work inspectorate. Basically, written remote working agreements. Also, as we already mentioned, the employer will have to provide all tools and equipments needed for the remote work to the employee. Very important here, there is like a provision in the new act saying that the employee cannot use his or her personal belongings for the provision of remote work. And now we have a question, what about bring your own devices policies? Okay. No resolution now. It seems that it will not apply, that they will not be valid anymore. Let's wait for labor tribunals resolutions in this case. Then, as mentioned also, well, we will have to assume all the expenses incurred from the remote working schemes, and employers must guarantee the health and safety of the employees. This is very important. Why? Because the employers will have to make first a labor risk assessment, not only focus on those labor risks inherent to the job position, but also to those labor risks inherent to the remote working morality. Okay, then the corresponding prevention service of the company will have to make as well this labor risk assessment by taking into account only the limited space where the employee will provide services under remote working basis. On top of that, the company will have to follow a specific methodology in order to make this labor risk assessment. And in the event, but only in the event, the experts on prevention of labor risks from the company decide that they need to check or to make an inspection on the place, a physical inspections to the place where the employee will provide services on the remote worker basis, they can do that, as long as, first of all, they draft a written report that must be provided not only to the employee, but also to the employee's representatives, okay? And also as long as they get the employee's consent. So this is basically the main obligations. There are several obligations, but these are like basically these are like the basic ones. And then something else for you to take into account in relation to this new regulation is that remote workers will have several rights. Basically, they will have the same training, they will have the same rights on training and professional promotion as the office workers. Likewise, the employer must guarantee the health and safety of the remote workers, and this is considered and interpreted by Spanish courts in a wide sense. This means that the employer must take all measures they consider appropriate to avoid risk on health and safety to the employee. Also, very important, even employees will provide services from home. They will still obliged to continue reporting or register their working time in the corresponding recording system implemented by the company, and the company must ensure that they indeed report their working time every day. Also, they are entitled to digital disconnection and to all issues associated to data protection rights. So this is basically a general overview on the new Remote Working Act in Spain. It covers several items, but we just focus on these main ideas. In any case, we can go back in detail during the Q&A round. At the end of the session, if you consider appropriate. So now let's move to the other countries, and now it's Kaela's turn, France's turn. So Kaela, we know that some employees have been working from home in France, I think, during almost 1 year. So now employers would treat them as permanent remote working employees or not? So what is the French approach in this regard?
The answer is both yes and no, because even if you look at employees who are placed on telework or work from home only in relation to COVID, you still need to protect their health and safety like you would with permanent home workers. You also need to be monitoring their time because they're no longer on your premises. You don't know what time they come in, what time they leave, how long their breaks are. You don't know if maybe they're working overtime hours that you didn't ask them to, but they are anyway, which could open you up and expose you to litigation. So it's good to treat them similarly and make sure that you're properly monitoring their working time. You also need to, again, make sure that you make them aware of the means by which they can exercise the right to disconnect. But you do not need to treat them the same as permanent home workers in the sense that you don't owe them a work from home allowance that's usually owed to other permanent home workers. And you also don't need their consent. Yeah, I would definitely recommend that you do not ask them, specifically do not ask them for their consent, because if they're only working from home due to COVID, the employer is applying an exception permitted by law. In emergency cases, in exceptional cases, employers can require their employees to work from home without their consent, because ordinarily their consent would be needed for this type of working arrangement. There is also one area of legal uncertainty. It's with regard to whether home workers working at home just due to COVID are entitled to reimbursements of their costs related to working from home, because ordinarily employees are. But in this case, there's no real consensus about whether it's owed. Yeah, there's a lot of uncertainty. So if you want to talk about it in greater detail about your specific company, we can do that. But just know that at this point, it's unclear.
Okay, thank you very much, Kaela. And now, Marco, as I already mentioned, here in Spain, according to the new regulation, even if the employee provides services from home, even in that case, the employer must guarantee the health and safety of employees. So in relation to Italy, is the employer responsible for the remote workplace?
Thank you, Gisela. And my answer is yes and no too. So that it's very low. But that is true in the sense that in Italy we have two remote workings. One is called telelavoro, the other is called smart working. And one is ruled by a law, the 2017 law I was mentioning earlier, and it is in principle a task-based way of rendering the service. So no place, no time for the performance of the duties, if compatible with the duties themselves, and general information on health and safety and on working not in the office. And then the employee is free to work wherever he or she wants. There is no boundaries. It's just you have a job, you do that, it must be measurable. There are issues around the monitoring of performance, but fine, very fine. On the other hand, there's telelavoro, which is proper home working, meaning you don't go to the office, you stay at home, but home is the office. So you have working time, so you have breaks. So the employer is responsible for setting up whatever is needed, from the chair to the screen, to the distance between the eyes and the screen, and whatever the light, how it comes out, as if it was a workplace. Now, currently, we're in emergency smart working mode, meaning free for all, just notify authorities the name, and that person is going to be working in smart working, first sense, and it's fine. That is going to end currently at the end of March. So probably the legislator will either take position on remote working with a new arrangement or not. Currently, it's an individual agreement, it's task-based, and it's simplified ways of rendering the service. Thank you.
Thank you, Marco. And what about US? Rachel, do you expect that Biden administration to make any rules, laws about working from home?
No, actually, the US has taken a very hands-off approach when it comes to legislating work from home, and it's pretty much left up to the individual states. There are certain states such as California, which regulate expenses, the reimbursability of expenses working from home. And I expect those to start coming forward a lot more in the coming weeks and months as the legislative sessions become more active. But what I've recommended for US employers is take a look at your policies and procedures and see, are they really addressing work from home issues? Most employee handbooks and policies are designed for, the mortar kind of buildings that you go to every day and not from working in the office. And so take a look at your policies and procedures, as well as your insurance policies, to see if it's addressing work from home issues. And if they aren't, then it's time to revise those if you are considering a more permanent work from home situation as an employer.
Okay, now, thank you. Okay, so now, Kaela, now it's your turn, and I will appreciate if you can give us some feedback on working from abroad based on a French legal perspective.
Sure. So I think almost all of you have already faced a question or a situation where an employee asks you to work abroad during COVID because you've asked them to work from home and they think, well, instead of working in the US, I prefer to work from my family home in France. Or instead of working as I usually do in Italy, I'd like to go to Spain. And in that situation, there are some important consequences that you need to consider before making this decision. First of all, how will this, what are the consequences under employment law in the foreign country? What are the social security consequences? What are the income tax consequences? What are the corporate law consequences? And also, what are the immigration consequences? That's more a question for your employee to see whether or not they can actually reside and work abroad, but it is something that you need to keep in mind. In France, it's much easier for European employees to work in France because of the way that Europe is regulated because of the EU. But for we would consider them third-party countries or non-EU countries, it can be a lot more complicated. Going back a little bit, just in terms of French employment law, if you have an employee who's coming to France temporarily to work due to COVID, you should really be posting them to France. And depending on the situation, you may have to file a pre-posting declaration. You may have to appoint a company representative for posting purposes. There are a whole host of laws that cover posting in France that you'll need to comply with. In particular, as an employer, as a foreign employer, you would have to comply with the core employment laws in France for the first 12 months. It's a limited list, but you have to comply with those. It includes remuneration, it includes working time regulations, and you need to treat your posted employees in France equally with employees in France holding the similar positions in the same industry. So it's not just meeting minimum requirements, but it's meeting equal requirements, equal treatment requirements. If your employee stays longer than 12 months in France, as of the 13th month, nearly all of French employment law will apply. And that includes not only statutory laws, but also collective bargaining agreements. There are certain exceptions like laws governing hiring, laws governing fixed term contracts, dismissals, which is important, laws governing modifications of contracts, as well as transfers. But once you're past 24 months, you really have to wonder, is this person posted or are they permanently working in France? In which case, all the French law could apply to your employee as of that point. In terms of Social Security for EU and EFTA countries, including Iceland, Liechtenstein, Norway, and Sweden, Switzerland, it's easy for employees to work in France and still be covered by their home country's Social Security, provided that they have an A1 certificate, and that'll allow them to remain under their country's Social Security for a maximum of 24 months. But for the rest of the world, it really depends. It depends on whether you have a treaty with France or not. And this question is actually really important because if you are required as an employer to enroll your employee with French Social Security, that means that you also have to take the administrative steps to enroll as an employer in France. It's not a difficult process, but it's something that you will have to do if you have any employees who are enrolled with French Social Security. Also, in terms of income tax, it's important to know where your employee will be taxed, because if the employee is subject to French income tax, you will have to make withholdings. And if you do not, penalties will apply. And the penalties are 10% of what should have been withheld, with a minimum of 250 euros per month. So if you have an employee who's posted in France who really should be paying French income taxes and you don't, your penalties can rack up very quickly. They can add up quickly. But practically, if you only have one employee in France, it's possible that the work inspector will never find out about them, that the tax authorities will never find out about them, and that your actual risk is relatively low. We are running out of time. So let me just see here from Italy. Can employers prevent employees from working abroad?
Well, the answer this time is a no, meaning there is no specific prohibition when we're in a smart working mode or the employee decide to do so, and it can be done. There is a general duty to be available even during furlough, so it must be managed through this. The advice is to formalize the position of the company. So if you do have a smart working arrangement, do insert a prohibition to work abroad. So it's there. If you want to allow this, make a specific agreement on governing law, tax issues, how to get back, and also health and safety, because as we know, we're all navigating the pandemic together, but each state has its own rules. So even thinking about cross-border movements can imply a number of restriction and waiting lists and maybe vaccination on the employee. So be clear, use policies, be clear in advance with your employees to avoid complicated situations going forward. That's the Italian advice in this regard. Thanks, Kayla, and thanks everybody.
While I have other questions for the other countries, I know that we're running out of time. So I'm going to allow Marco to close us out.
Well, thanks again, and thanks to the panelists. It's really been a pleasure seeing you and allow me this time. And it's been a pleasure not seeing you all, but talking to you, because, you know, keeping the discussion open is the way to navigate this pandemic forward. There have been questions, 6 of them, and we'll be maybe getting back to you by emails. Apologies, but time, as you know, in smart working mode is always an issue. So we did lost track of it sometime along the way. Thanks everybody, and hopefully see you all again soon when this is over. Thanks.
Thanks, y'all.
Thank you.
Thank you very much.
And the other panelists. So as Marco mentioned, we didn't have the time to take the questions that came in today, but I will send our panelists a report of those so they can get back to the ones who send them. I have also included some links, interesting links to our website, to the reports that we've done on the same topic, about podcasts as well, that you can check. So the slides will be available for download on our website after the webinar. You will receive a follow-up email, so you have that. So yes, thank you also from my side for joining, and thanks also our panelists for all of their important insights today. So with that, this webinar will now be ending. Thank you.